You're staring at a trademark filing checklist for the very first time. You're probably unsure if the mark you picked will even survive USPTO review, and you're wondering whether that $350 fee is the whole story or literally just the start of it. This explainer walks through exactly how a trademark application moves through the Trademark Center and what actually determines whether it registers or gets refused.
Here's the roadmap for this explainer. We'll cover the real cost to file, intent to use versus actual use, the Trademark Center filing steps, why applications get refused, timelines and public oppositions, and finally, filing pro se versus using professional representation.
All right, Section 1, the real cost to file.
Filing your application runs entirely through the Trademark Center now. That's the portal that officially replaced the legacy TES system back on January 18, 2025. Entering this system starts with a base fee of $350 per class of goods or services. That's the baseline required just to submit your application for review. But listen, that $350 is rarely the only number you need to worry about. The system has strict structural rules, and missing them triggers hidden surcharges that catch a lot of applicants by surprise. For instance, there's a $200 per class penalty if you use free-form custom descriptions for your goods and services instead of selecting pre-approved terms right from the USPTO ID manual. And if you want the full fee breakdown, including the surcharges most applicants get hit with unexpectedly, the complete article is linked in the first comment below. Let's move to Section 2, Intent to Use versus Actual Use. You have to make a strategic choice here between two distinct filing bases. Section 1A, Use in Commerce, requires you to already be selling to the public. You need an active, verified specimen at the exact time of filing, and a successful review leads directly to a registration certificate. Now, Section 1B, Intent to Use, is designed for when you haven't actually launched yet. It locks in your priority date and protects your spot in line. However, a successful review here doesn't grant immediate registration. It gets you a notice of allowance.
So choosing Section 1B means you're committing to a second step. Once that notice of allowance issues, you have to return to the USPTO later to file a statement of use, which legally proves your actual commercial use has begun. Filing that document carries an additional fee of $150 per class.
With your basis selected, we arrive at Section 3, the Trademark Center filing steps. The mechanical workflow inside the portal really boils down to 5 stages. First, enter the legal owner's information. Second, select your mark format, like standard characters for broad word protection, or a special form if it's a logo. Third, identify your goods and services via their NICE class. By the way, carefully selecting those pre-approved ID manual descriptions here massively reduces your risk of facing an office action later. Fourth, select your Section 1 basis and upload your specimen if you're filing under actual use. Finally, pay the fee to instantly receive your tracking serial number.
But submitting is just the administrative hurdle. Let's look at Section 4, why applications get refused. Having reviewed applications from inside the USPTO as former examining attorneys, we know exactly where filings fail. Most refusals aren't paperwork errors. They happen during the rigorous substantive legal review. The most common hurdle is a Section 2D rejection for likelihood of confusion. This is a Lanham Act refusal that drops when an examining attorney determines a newly filed mark is simply too similar to one already sitting on the register. The examiner doesn't just guess, though. They weigh this similarity using a strict set of criteria known as the DuPont factors.
The second most common roadblock is Section 2E1, mere descriptiveness. This refusal comes up when a mark simply describes the goods or services being offered, rather than acting as a distinct, unique identifier for the brand. The examining attorney evaluates this by looking at the primary significance of the words to the relevant purchasing public. Basically, if your mark just tells the consumer what your business does, it's going to face this refusal.
Knowing those risks, let's shift to Section 5, timelines and public oppositions.
After you click Submit, you enter a deliberate waiting game, so setting realistic, unhurried expectations is crucial. From day one, your filing date, the application typically sits completely untouched for 8 to 10 months before an examining attorney even picks it up for initial review. If the path is perfectly clean, no office actions, no substantive refusals, a typical registration takes anywhere from 12 to 18 months total.
And remember, examiner approval doesn't mean immediate registration. Your mark must first survive a 30-day publication window in the Trademark Official Gazette. During this exact 30-day stretch, third parties have the right to file a formal opposition with the Trademark Trial and Appeal Board if they believe your registration will somehow damage their existing business.
Which brings us to Section 6,
filing pro se versus professional.
Navigating the Lanham Act and USPTO procedures all alone carries a distinct set of technical burdens. You're entirely responsible for submitting a legally verified specimen, navigating the ID manual perfectly to avoid those surcharges, and most importantly, anticipating and arguing against complex Section 2D and Section 2E1 refusals. When applicants utilize professional representation, the total cost for a single class application typically runs between $1,500 and $3,500. That investment really provides the analytical lens needed to anticipate these exact refusals before they're issued, weighing the application exactly as an examining attorney would.
But regardless of who actually presses submit on the application, it all comes down to this singular truth. The mark itself and the specimen matter more to registration than any step in the filing process. Substantive legal readiness dictates your success far more than simply checking the right boxes inside the Trademark Center.
The full article breaks down all 5 Trademark Center steps and the Section 1A versus 1B decision in detail, and it is linked in the first comment. Subscribe if you want practical USPTO and patent guidance without having to go looking for it each time. Before you click Submit and spend that non-refundable fee, you have to ask yourself, is your business name truly distinct enough to survive the examiner's desk, or are you just buying a $350 rejection letter?